All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Morning, counsel. Let me call the case. Court calls case number CV150144. This is Courtney Ray St. George and John St. George v. Charles Stephen Plimpton et al. This is the time set for oral argument. Counsel, you're probably well aware that you both have 20 minutes for your oral argument. Mr. Rivera, when you get up to present your argument, if you want to reserve some time for rebuttal, just let us know. Both of you probably are also aware these are recorded audio and visual recordings, and they're uploaded to our website, so that'll be available for people to view after today's argument. We've reviewed the briefs, we're familiar with the case, we've conferenced the case, so keep that in mind as you present your arguments. Mr. Rivera?
Yes, sir.
Good morning, Your Honors. Sal Rivera on behalf of the appellant, Courtney Ray and John St. George. As you know, this is a medical malpractice case in which my client alleges that she was seriously injured as a result of the negligence of Dr. Plimpton and Ms. Franklin, nurse practitioner, Ms. Franklin. And the court, over our objections, obviously granted summary judgment to both defendants, and that's why we're here today. In preparing for today's oral argument, I think it is absolutely clear, with all due respect to Judge Starr, that Judge Plimpton should not have been granted summary judgment. I have direct testimony from a qualified medical professional, doctor, board certified in the same area as Dr. Plimpton, in which he said that Dr. Plimpton's care of Courtney, my client, fell below a reasonable degree of medical probability. And what you've seen in the briefs and what you're undoubtedly going to hear today is, well, Dr. Waters, our expert, also said in other areas of his deposition that he did not believe that Dr. Plimpton fell below the standard of care. And that's something that we'll have to deal with at trial. But this was a summary judgment motion. During oral argument on summary judgment, I read specifically into the record the following. And this is me to Judge Starr. Dr. Waters, in his deposition, Mr. Kent, who was trial counsel for Dr. Plimpton, said, Mr. Kent just told you there's 100%. He said nothing in Dr. Waters' testimony, 100%, that does not implicate or suggest that Dr. Waters believes that Plimpton fell below the standard of care. Your Honor, I asked the judge, you said you have the deposition transcript in front of you or with you. The court responded, I do. And I said, and you've read it. On page 20, line 21, Mr. Kent, again trial counsel, asked Dr. Waters, well, you understand, doctor, I'm here to find out your specific opinions. Are you going to be able to state to a reasonable degree of medical probability that Dr. Plimpton fell below the standard of care in this case? Answer by Dr. Waters. If he is a supervising physician of the midwife and they either have an arrangement financially or contractually, which they do, the relationship falls below the standard of care.
Is this a negligent supervision case, counsel?
It does include a negligent supervision.
Against
Dr.
Plimpton?
Yes, it does. Absolutely, Your Honor. And subsequent to the deposition.
To me, counsel, that was directed against the hospital. Are you sure about that?
Absolutely, Your Honor.
The hospital has been dismissed.
The hospital has been dismissed, Your Honor. And this was directly about Dr. Plimpton. And if there could be no question, and we had an issue about this also, after his deposition, Dr. Waters, our expert, issued a form of correction to the deposition, which the court accepted, in which I'm not going to read this into the record in the interest of time, but basically said, I believe that Plimpton violated his obligation by hiring a nurse midwife who is not working under a protocol in his office and was not given a set of protocols to appropriately monitor patients. Even under all of these other things, basically summarizing our position is that the main thing that Dr. Plimpton did in this case.
Can I ask you a question?
Yes, sir.
Did your expert, Dr. Waters, ever testify that Dr. Plimpton knew or should have known that the nurse midwife Franklin was not competent or Is there any allegation like that, any testimony on his part?
Well, specifically with regard to this issue, what he says here in his corrections is it appears that Plimpton was unaware that there was meconium and was unaware that there were changes in the fetal heart rate. Furthermore, in the deposition of Courtney Ray, which I have recently reviewed, she recalls the fact that Dr. Plimpton was called because of Dr. Plimpton using his big hands, clearly additional stretching, pressure of the perineum, and of the pelvic under the circumstances of what defense has said is a known cause of pubic separation.
Counsel, my question was...
Well, go ahead.
My question is a little more specific. There's a Humana Hospital Desert Valley case, it's 154 Arizona 396, which talks about in a negligent supervision claim, the employer's failure has to encompass some knowledge that this employee that they were supposed to supervise wasn't competent, or they knew or should have known they weren't competent or capable of doing the job. Isn't that what that case says?
And we have that evidence, Your Honor. In this particular case, and it's part of the record.
Well, hold on. Did your expert testify to that at his deposition?
Dr. Plimpton admitted that he was disciplined in some manner, and I don't remember what level of discipline, for failing to properly supervise his nurse practitioner. Twice.
In this case?
In this case.
Not related to this case specifically, that previously had, and that was part of the record in this case.
So it seems to me that you're distinguishing then between a negligent supervision case and a negligent care case as potentially two separate claims, right?
I believe those are two separate claims,
Okay.
and I believe we've asserted both, Your Honor.
And your opening in this argument related to evidence that you had concerning negligent supervision, or an opinion regarding negligent supervision.
Part of that is.
Did that opinion embody sufficient evidence under the case Judge Gould mentioned to make a prima facie case for negligent supervision?
I believe it absolutely did, Your Honor, but that wasn't the issue that was briefed on the motion for summary judgment.
Okay.
The issue that was briefed on the summary judgment motion was whether Dr. Plimpton, that issue, as far as I can tell and remember, and obviously this was a couple years ago, but I've done plenty of preparation for today, that argument wasn't an argument that was raised at the summary judgment level, and so that is not something that the court considered or ruled on. This was whether, A, Dr. Franklin was qualified, and the position, and what we're arguing is, the position that the court took was not that we didn't establish a prima facie case under Humana. The position the court took, and why we believe it erred, was that Dr. Franklin, in certain parts of his deposition testimony, said that he didn't believe that...
Dr. Waters?
I'm sorry if I said Dr. Plimpton.
That's okay.
That Dr. Waters, in certain part of Dr. Waters' deposition testimony, said that he didn't believe that Dr. Plimpton fell below the standard of care.
Okay.
And so my argument is that she focused on one portion of the deposition testimony and ignored both the correction sheet, which talks about direct negligence, and failure to properly supervise. But she
Okay.
granted summary judgment anyways.
If we take out the relationship, the alleged impropriety of the relationship, and we just look at negligence in treatment, okay, there is some testimony suggesting that there's no breach of the standard of care. What's the best testimony or part of the correction sheet that conflicts with that?
Well, in the correction sheet, Dr. Plimpton says both, that he violated, Dr. Waters says that Dr. Plimpton violated his obligation in hiring a nurse midwife, one, but then he also says, furthermore, in the deposition of Courtney Ray, Dr. Plimpton was called because of Dr. Plimpton's need for his big hands, and there he clarified that the additional stretching of Courtney's body basically caused and contributed to her
But isn't that
catastrophic
causation
injuries.
rather than standard of care? I mean, there is this artificial divide, I think it's artificial, between standard of care and causation in med-mal cases. I think what we're looking for is some area of conflict in the deposition or correction sheet with regard to Dr. Plimpton's compliance with the standard of care.
And I believe, and it's our position, and why I believe, again, respectfully to Judge Starr, she erred is because we had evidence of that. And on both, on standard of care, what the standard of care was, and it wasn't until I started doing these cases that I really started to learn the distinction, both on the standard of care and also on causation. And he said both things.
Okay,
and
what did he say on standard of care? Because I'm sorry, I'm still missing it.
Oh, he said on a number of occasions, both in his preliminary affidavit and in his deposition, and then in his correction sheet, that Dr. Plimpton, just Dr. Plimpton right now, fell below the standard of care in his supervision, in how he handled, that he wasn't more involved, that he didn't recommend a C-section for Courtney. Those are the ways that he personally violated the standard of care.
All right.
And he then testified that those violations were the cause of Courtney's injuries.
Counsel, hold
yes,
on.
sir. Yes, sir.
That's okay. Where in the record does Dr. Waters say it was a breach of the standard of care not to recommend a C-section by Dr. Plimpton?
It is in, I'm pretty sure it's in his preliminary affidavit, but that is a document that I don't have with me right here in front of me.
I mean, when I look at the deposition, and I looked at the deposition, I looked at the corrections, and there's just this rather alarming exchange here. I think you know what I'm going to point to. It's in the deposition, it's our record 138, page 23, question. So as you sit here today, you cannot state to a reasonable degree of probability that Dr. Plimpton actually fell below the standard of care. Answer, that's correct. I'm not sure. Now, I read the corrections page, and there was some discussion about the relationship wasn't very good between the two of them. But where is the specific section that addresses that?
Your Honor, I had specifically addressed that in our oral argument, which obviously is part of the record, when Mr. Kent asked Dr. Plimpton, Dr. Waters, I apologize, when Mr. Kent asked Dr. Waters, where did he fall below the standard of care? And what Dr. Waters says is, if he is a supervising physician of the midwife, and they either have an arrangement financially or contractually, which they do, their relationship falls below the standard of care. Now, the relationship here, just to be clear, and I know you folks understand this, we're not talking about a personal relationship or any sort of romantic relationship. We're talking about the relationship in which they worked, the supervision, and how he supervised her. And that is the core of what he was talking about. His primary complaint was that he should have been much more involved in the supervision and guidance and recommendations that my client received during this delivery, and he was completely absent. And I would say to you also, Your Honor, a major point I want to make is, if you were our jury, and if we were standing in front of you today and I had to explain these things, which obviously this thing should be remanded and go back to a jury, I've got some explaining to do, as they say. I've got some explaining to do. I have to tell the jury why Dr. Waters said what he said over here and why he said what he said over here, okay? And I believe I can explain that. But on a summary judgment motion, I do not believe it's the court, not on a bench trial, but I do not believe it's the court's jurisdiction or place to say, we're not talking about scintilla of evidence here or anything like that, for a court to ignore testimony from a qualified expert where he says that Dr. Plimpton fell below the standard of care. I was hoping to save 6 minutes, not use most of my minutes on just Dr. Plimpton. On Miss Franklin, I think we've presented a very strong argument.
Hold on, Mr. Rivera.
Yeah.
I know you've got two issues here. You've got Nurse Franklin and you've got Dr. Plimpton. I'll give both of you an additional 3 minutes. All right?
That's fine with me. Your Honor.
I don't want you to rush.
Okay. Well, I'm already rushing, but I'm going to get through it. I want to answer your questions because whatever I have to say is not as important as answering your questions. So, very briefly, I think we have presented a very strong argument.
Make sure you answer my questions. His questions are not important, but answer my questions.
I heard your exchange earlier, and, Your Honor, with all due respect, I'm not going to get in the middle of that, please.
The fact that mine are less wordy doesn't mean they're less important.
Okay, that was...
And yet we're not here to discuss our existential existence either. Go ahead.
Give me
And I
4
appreciate
minutes.
all of that, and now, can I have 20 more seconds now that I've had to hear that? Judge Orozco, thank you. If you have a question for me, by all means, let me know. Let me get back to serious business here, because this is serious business. We believe that we've presented a strong argument based on strong standard canons of statutory construction that Ms. Franklin was negligent per se. Now, the other side has suggested that our arguments make no sense, but pursuant to the statutes that we've cited, licensed midwives are exempted from the licensure scheme of 36751, which deals with midwives. But that's all of that they're exempted from. 752 and 753 753 gives the director the authority to adopt regulations and powers over the ability to regulate nurse midwives, and it doesn't say anything in those sections or anywhere in the statute that she is excluded from complying with the regulations dealing with midwives. Now, that's one argument that I think is a very interesting legal argument, and one that I think the court has to grapple with, because as the court knows so well, if the legislature doesn't say in all of the areas that certain class, for example, is excluded, then the court, it's not the court's role, with all due respect and as a member of the bar, for the court to interject itself and say, well, we're going to put this requirement in over here for this class of people, even though the legislature hasn't spoken on that.
Could they make a clearer statement than saying the licensing requirements just don't apply to certified nurses? I mean, I understand what you're saying, but are we really required to do a lot of analysis? And is there, I mean, they just directly say the licensing requirements don't apply. You read that as the licensing requirements don't apply to nurses, but everything else we say in this section does.
Or else they wouldn't say that, Your Honor. I think absolutely.
Does that section apply to obstetricians?
There's a separate section that deals with obstetricians. There are specific categories that deal with specific classes. And I think if the legislature doesn't say it, then we as lawyers and the courts are bound by what the legislature does and has said. But let me fast forward, because I'm down to 3 minutes. And
you should have 6 minutes.
And I got that, and I thank you for that, Your Honor, very much. But let me take you to my going home argument, okay? In all the cases that I have read, and by the way, counsel for Ms. Franklin has cited a couple different cases that don't comply with the rules for supplemental identification of supplemental authority. What I would ask is that they be required to do so, and we be given the opportunity to likewise respond to what they believe the cases mean. But in the cases we've seen, and as recently as 2016, and the court is well familiar with the statutes 2603 and 2604 are adopted to establish an orderly process by which medical malpractice cases can proceed, all of that kind of thing. But what these cases all hold is if the defendants object to the nature or type of doctor or medical professional that has been identified in the Razor case that was just disclosed, in the Baker case, in all of these cases, the Court of Appeals has held that you should give the plaintiff, the injured party, additional time to go seek to obtain a medical professional who does comply. So in other words, my point is, and in one case they didn't even identify an anesthesiologist, and the Court of Appeals said it was error for the trial court not to give those plaintiffs additional time to get a qualified anesthesiologist. the point here to remember is, from my perspective, is these statutes were not adopted to limit a plaintiff's right to bring a medical malpractice claim. They're provided as kind of a mechanism so that the defendants know what they're defending against, one, and two, so that I can't come in here and tell you that I ate KFC for 6 weeks, have a heart attack tomorrow, and then stand up in front of a jury and say, hey, I get to the jury because it's my opinion that that's what caused my heart attack. They say you got to have a qualified medical professional, but they don't and aren't intended to be a full employment act for medical professionals to testify in other cases. They weren't intended to exclude cases. They just mean that the qualified cases that you can say there's adequate medical evidence to proceed on should be heard by a jury. And that's why when you read all the cases together, the judges, the courts, this court of appeals has consistently granted defendants, plaintiffs additional time to identify the proper experts. And I asked for
Was
that.
that request made? It wasn't technically a Rule 56F request, but I know 2603 has additional measures for additional time. How specifically in the record can we find that request?
But, Your Honor, oral argument. But, Your Honor, I will go back to, if that's what the court is thinking, if that's the direction the court is heading in, there will be no prejudice to any party if the court grants us 30 or 45 days to get a midwife, who candidly is going to be as critical of Nurse Franklin as Dr. Waters is. And you know this court, Your Honor, a lot of these statutes came about to ensure that that there was somebody who was going to be critical, not a lawyer or a layperson, who was going to be critical of the medical care provided. That was the justification and explanation for these statutes. Now, defense counsel in these types of cases want to make a lot of it and use these statutes to create new hurdles.
I don't want to use too much.
I know.
Of your time
I'm trying to
with
get to it. I'm trying to get to it, Judge Swan. Okay. Here it is. And if this court says I need a certified nurse midwife to be critical of Ellen Franklin, then, Your Honor, I will respect that decision. I think we've presented the reasons I don't, but if you're inclined to do that, then just give me a short period of time, as the Court of Appeals did in Baker and the Supreme Court did in Baker, and we will get it. We will present to this court a new scheduling order so we can get this case resolved, and we will resolve it on the merits, Your Honor. I thank you for your time.
So your position then is that you don't need Rule 56F because you've got 2603C.
Exactly. And you know what? And the Razor case and those other cases, the court granted additional time after summary judgment was filed. The Court of Appeals granted reversed and said the trial court should have granted additional time after summary judgment was granted and the discovery deadline had passed. And I think that they're the same basis for doing so in this case. I reserve whatever little bit of time I have left.
Well, let me ask you this, counsel. This case was 2 years old by the time the judge granted summary judgment. When does your client recognize what their obligations are in terms of obtaining an expert under 122604? When is the appropriate time for that?
Well, I think, Your Honor, I think if I remember correctly, we filed our affidavit of merit a little late, but relatively early in the case. It was never challenged. This is not part of the record, so I'm not going to go into great detail. But
if it's not in the record, I don't want to hear it.
Okay. My point is that the case was on hold for an extended period of time for reasons that were not our fault. We disclosed our expert. We disclosed our expert reports, and this matter was not resolved for another 7 or 8 months afterwards, and nobody raised it. And that's kind of the holding of, well, not kind of, that in my reading is the holding of Razor and the other cases, which goes back to the old disclosure rules.
Not the holding of Baker. Baker was a different situation.
No.
They explain in that it was fairly debatable. I know he said other cases, and when you mentioned Baker in support of your argument a minute ago, Baker was a different situation. That was a debatable issue about what 2604 required.
And
Here it's required. You know it's required. 2 years into the case, at the end of an oral argument, you raise to the court, well, can I go out and get a nurse midwife now?
Yeah.
That's the way it came up.
And I think two things. First of all, Baker was almost simultaneous with our case, and the Baker in the Court of Appeals, I believe it was, not the Supreme Court, said that at that time, at about the time our case was filed and pending, said that the 2603, 2604 statutes, in the court's words, were confusing, were ambiguous. And so that's the environment in which I'm dealing with, and this case is pending. Thing one. And thing two, the Razor case, which did the same thing, which this Court of Appeals ruled on in, I believe, of May of 2016, said, no, trial court, you should have given them additional time. And that was as recently, and it's in my, I put my book down, but I believe that's as recently as February of this year. So this court is still saying folks should be given the right amount of time to comply with this statute if it's an issue. And we have done everything in good faith to, we did our declaration, our affidavit of merit, we did the deposition, we did corrections, and yeah, if they didn't raise that and now I've got to deal with it, then I say give me 30 days. And what's the prejudice? There's been no evidence in the record that any party would have been prejudiced by that. Thank you, Your Honor.
All right. Thank you, counsel. Counsel?
Good morning, Your Honors. I'm Eileen Gilbride here for Dr. Plimpton. With me at counsel table is Steve Yost, and he's here for Nurse Franklin. I am going to take no more than 10 minutes and then turn it over to him for the rest. I'd just like to start by answering the court's question about the alleged negligent supervision claim. There wasn't one against Dr. Plimpton. I just reviewed the complaint again. Count 1 was a straight negligence claim, and count 2 was a negligent supervision claim against the hospital. And so there wasn't one. So whatever it means for the relationship to fall below the standard of care, I'm not sure what that means. I'm not even sure that even gets to negligent supervision. But whatever it is doesn't apply to Dr. Plimpton. I really don't have a lot to add to our briefing. Nowhere in the record did Dr. Waters testify that Dr. Plimpton fell below the standard of care by doing or not doing XYZ, and that conduct caused plaintiff injury. To the contrary, in fact, as you know, Judge, you read right out of his deposition, he affirmatively testified that Dr. Plimpton did not fall below the standard of care. The correction letter, which really is not a correction letter at all, it's an unsworn piece of paper with additional opinions on it.
Well, typically what you see in a correction letter is page and line
Exactly.
correcting an answer.
That's exactly right.
It's just a paragraph that sort of characterizes the testimony, so I don't even know specifically what that is correcting in the deposition.
It's not. It's just, like I said, an unsworn piece of paper that has different opinions on it. So it's really not a correction letter at all, and it shouldn't be considered. But even if you do, it doesn't matter because it doesn't say anywhere that Dr. Plimpton fell below the standard of care, as I was saying before. Same thing with the preliminary affidavit. It shouldn't be considered to controvert the clear testimony in his deposition.
Well, why not? I mean, we see this frequently where there's a conflict between an affidavit and a deposition. I mean, does that really defeat the existence of a dispute of fact, or does that just muddy the waters and create a dispute of fact?
It doesn't create
I mean,
a fact issue.
Well, okay, it doesn't create a fact. I'm sorry, that was inartful. It doesn't create a fact issue. But if you have a witness saying one thing and then later contradicting that, is that not a matter for the trier of fact? Is that not a credibility determination?
Not under the sham affidavit rule. And that's pretty well settled Arizona law, that you can't, when his deposition testimony was so clear, and the affidavit, this preliminary affidavit was a year earlier, obviously, and defense counsel, trial counsel asked Dr. paragraph by paragraph, went through that affidavit, And Dr. Waters said, I can't say that Dr. Plimpton fell below the standard of care. Then the plaintiff can't go back and say, oh yeah, he did testify to that, but go look at the preliminary affidavit and maybe there's a fact question that was created. That's what the sham affidavit rule is designed to avoid. And even if you don't apply the sham affidavit rule, still the preliminary affidavit doesn't say Dr. Plimpton fell below the standard of care by doing X, Y, Z, and that caused plaintiff injury. So, you shouldn't consider it. But even if you do, it doesn't matter. It just, there's no question of fact here. And the record is clear. He didn't fall below standard of care.
But I'm not even sure the sham affidavit rule applies because the correction letter isn't even sworn.
Well, we're talking about the preliminary affidavit and the correction letter are two different things.
But the correction letter is not even sworn. It's not even an affidavit. I mean, sometimes you'll see deponents come back with an affidavit and
Right.
be sworn, but not with just a
a
statement.
piece of paper. I agree with you. And even if the sham affidavit rule doesn't apply to the correction letter, it's still not an appropriate correction letter. And
The sham affidavit rule, though, only applies when the two statements really join issue, when they're truly inconsistent. And I think
Right.
what Mr. Rivera has argued is that there is a difference in scope between the question and the deposition, and the deposition considered in its totality, including the correction. Am I wrong?
I honestly didn't understand what his argument was. But if you can consider the whole deposition if you want. That's fine. Consider that, consider the correction letter, consider the preliminary affidavit. None of it says Dr. Plimpton fell below the standard of care and this by doing X, Y, Z and this caused her injury. You can consider it all. That's fine. I really don't have any more to add. The testimony was so clear in the deposition. It was subject to cross-examination. That's what we go with, and that's really all there is to say. We'd just ask you to affirm unless you have questions.
Sure.
Thank
Thank
you,
you.
counsel. Mr. Yost? You're addressing Nurse Franklin, Mr. Yost?
Yes, Your Honor. I'm Steve Yost. I represent certified nurse midwife Ellen Franklin. I acknowledge the Court of Appeals in several cases has held dismissal with prejudice is not available to a party under certain circumstances where the opposing party fails to submit standard of care opinion from a qualified expert. As Judge Gould mentioned, I don't believe either the Court of Appeals or the Supreme Court in Baker, which I briefed and argued, both of those, applies in this situation. The law was changed twice to get to where we are now in those decisions. Specifically here, though, where a motion to dismiss under 2603 was filed on behalf of Ms. Franklin, the specialty of certified nurse midwife Franklin is open and obvious. There's no dispute. Occasionally we hear in these cases where there are multiple subspecialties, what was the specialty being practiced by the doctor creates confusion for the other side. That's not the case here. And the plaintiff, despite all that, proceeds to a summary judgment motion, opposes the summary judgment motion with a negligence per se argument that had never been disclosed, with a statutory basis that I have argued doesn't apply. Ms. Franklin is a certified nurse midwife, not a licensed midwife. They litigate to a judgment, and only at the argument when it's obvious the judge is saying, this isn't going anywhere for you, then asks, after 2.5 years of litigation, for more time. 2603 and 2604 were not meant to nullify Rule 56. And I'm going to talk about these cases. I've been involved in some of them. My law firm has been involved in other ones. They're all distinguishable. For example, the anesthesiology case mentioned by counsel, Sanchez versus Old Pueblo, is distinguished because it involved a dismissal with prejudice in connection with a 2603 motion. And 2603 doesn't even authorize that result. It was not a summary judgment proceeding. Preston v. Amade is distinguished, that's my case, because no motion to dismiss was filed. No motion to dismiss was filed because the affidavit of the expert declared he was qualified. It turned out in his deposition he wasn't practicing the specialty of internal medicine, he was practicing cardiology. I grant you that the Court of Appeals, this court, said there's a do-over, the plaintiff gets more time to find that expert, but it was because a 2603 motion to dismiss was not filed, and one was here. Razor is distinguished because in that case, my law firm was involved in it, the plaintiff affirmatively moved the court to authorize a certain wound care expert, and the judge granted that. Later, my office filed a motion for summary judgment saying that nurse was not qualified, and the judge acknowledged that, granted the judgment, and gave the plaintiff more time. Here, no court, no person, no one told the plaintiff that either Dr. Waters or a licensed midwife or anybody else was qualified other than a certified nurse midwife licensed by a nursing board. And again, there's no, in the Preston case, there was some confusion. Is it internal medicine or is it the subspecialty of cardiology? There's no confusion here. This was always a nurse midwife. She's identified as such in the complaint. She's identified as such in the motion to dismiss. So the motion to dismiss was filed in February of 2013. It was later withdrawn when the Dr. Waters affidavit comes forward. The motion for summary judgment is filed a year later in February of 2014. I enter the case after the motion is pending, and that motion sits for 6 months before a response is filed. At no time did a request come for more time. Instead, plaintiff responded. And so I guess what I'm here asking this court to think about is, by not applying Rule 56 to medical negligence cases, are we creating a separate category of cases where it doesn't apply when the question is, has a qualified expert been presented to provide admissible opinion testimony on the standard of care? So what if that is the law, that Rule 56 doesn't apply, then the pretrial expert witness orders, the discovery cutoff, the trial setting orders are all mooted when a party erroneously or deliberately chooses or just says, I'm going to defy 2603 and 04, I'm going to use the expert I want. And this statute's been the law since 2004. Grant you it's been clarified. I grant you that. But it's been on the books since 2004.
Isn't the purpose of the preliminary affidavit to, at the outset of the case, establish that there are qualified experts to testify on standard of care and causation? Isn't that the purpose of that statute?
Exactly right. And the Baker Supreme Court said, it goes a step farther than that, that is the time in which, if there's a dispute about what the specialty is, for the trial judge to enter an order to say, in this case, the specialty is obstetric gynecology, or the next case is hematology. In this case, there was no dispute about Ms. Franklin. She's a certified nurse midwife. There aren't any subspecialties of it. And the plaintiff chose to pursue this negligence per se theory, tried to...
I mean, some of the cases, like Cornerstone, there was an issue about what type of nurse, ICU nurses, RNs, that type of thing. Those issues, there was some lack of clarity there. It just seems to me in reading these cases, the case you were talking about, the Preston case, it's all been ironed out, and it's pretty clear you have to have either a specialist or someone who practices in that area. And if it's a nurse midwife, it has to be a nurse midwife. If it's an internal medicine doctor who dealt with a cardiac event, it has to be an internist, not a cardiologist. I just think these things seem to be pretty clear about what you have to do under 122604, and those would guide your avowals under 2602 and 2603 in the preliminary affidavit.
I agree with you, and I will grant the plaintiffs this. In cases in which all you see in the medical record is nurse RN, a reasonable lawyer may not know, well, is this really a wound care nurse or is it an ICU nurse? We don't have that here. This is a certified nurse midwife who is involved in the prenatal care and the delivery of this baby. So that, was not an issue ever in this case. I want to change the facts on a hypothetical, just 1 minute here, and see where this takes us. Let's say that the motion to dismiss is filed in this case, but a motion for summary judgment is not. And we say we're going to march this one to trial. And I cross-examine Dr. Waters on the witness stand, and it is absolutely clear to everybody he does not qualify as a nurse midwife. and I move for judgment as a matter of law. That has to be granted, and if it has to be granted in that setting when the pretrial statement has been done, years of litigation and expense has now coalesced to you don't have admissible evidence, then a motion for summary judgment has got to be granted unless the plaintiff says under Rule 56F, give me more time, please, and here's why. I didn't understand, whatever the case may be. That didn't happen here. And, these were deliberate choices, and I think a party has to be responsible for the choices they make in litigation. When they're given a repeated notice, they don't have a qualified expert. They choose to litigate it to the ground. They don't file a Rule 56F affidavit. This case is entirely distinguishable from the ones I mentioned, Preston, Sanchez, Razor, and all the rest of them, because of the fact there is no dispute about the specialty. So that's really all I have, Your Honors. If there's any questions, I'll be happy to try to address them. Thank you.
Thank you, counsel.
Your Honor, may I just have 30 seconds?
I'll give you 1 minute.
Okay, thank you. I just want to address a few things.
Hold on, any objection, counsel? Okay.
Thank you, Your Honor, and I'll be very brief. I just want to clarify for the record that the argument regarding 2603 was not something that was presented as part of this appeal, so we didn't have the opportunity to respond to it. The issue related to the correction letter was specifically rejected by the trial court. The trial court said that the correction, they filed a sham affidavit motion to strike Dr. Waters' correction letter. The court denied that. The defendants did not appeal that. That is not subject to appeal here. And the only thing I would add with regard to what counsel just said, and then I'll be done, is remember Dr. Waters, the other reason we believe that he was appropriate is because it goes to the relationship of how a doctor and a certified nurse midwife should work together. And Dr. Waters had extensive experience dealing with nurse midwives, certified nurse midwives, and it was that interconnection that we believe made him a proper witness. And again, I stand by it. If the court disagreed, then under the rules, as they were evolving, we should have been granted a short additional time to prepare and present that evidence.
Okay, thank you, counsel. We'll take this matter under advisement. We'll issue a written decision. Court's in recess.